benefit, then impaired director could apply. Our trend is moving away from it. We have the sole actor exception to the exception for adverse interest, but the state, the jurisdictions in the states are starting to move away from applying impaired director as harshly as they had before. But yet there are still some jurisdictions in which it is very ingrained. For instance, the New York folks, the Second Circuit and the Wagoner basically put it right at the top. You don't even get to discussions, it's a standing issue for them. So if you have an opportunity to bring your insolvency in a place that's going to be more beneficial for your lawsuits against third parties, then by all means you should do what is permissible. You should put that pretty high on your list. Particularly if you get appointed liquidator and there's no real hard assets, and you're looking at a litigation estate, if you will. Obviously, you should be picking the best place to do so. I will say that when they told me that this case just came out for Jativia, I thought it was one of those drugs advertised on late night TV. But hopefully this will become a welcome trend for the UK.
Okay, the next subject, power to assist foreign insolvency office holders. We have 3 points here. The first to cover, in Cayman, Bermuda, BVI's UNCITRAL model law is supposedly not enforced in these places. Well, in the case of the BVI, in 2003 we enacted our Insolvency Act, a modern form of legislation. It's a nice statute to read, quite comprehensive. We even have a part at the end of it that adopted the model law on cross-border insolvency cooperation developed by the United Nations Center for International Trade Law, UNCITRAL, in about 1996. However, I understand that before it was proclaimed, letters of representation from certain professionals went into government, and it was suggested that that part not be proclaimed and just be held in suspense indefinitely. And that's what happened. So we've never actually had UNCITRAL in force in the BVI. Recently, there's a controversy going on whereby various third-party forces, IMF, World Bank, /OECD, etc., that try and promote UNCITRAL as a part of their bag of promoting tricks and tools to improve developing nations' economies. And there are economists who do say you need sophisticated insolvency laws to run a proper economy, and you need, therefore, creditors' rights to attract capital, foreign capital, inward investment, and you need, therefore, insolvency cooperation and harmony in the world's insolvency system so creditors can recover assets that go spinning around the world. That's the case for UNCITRAL. The case against it is essentially smaller jurisdictions that have a high-value professional group of lawyers and accountants who work this pitch don't really like it in Cayman BVI because of the Comey rules, meaning center of main interest. So if a hedge fund is actually operated and the accounting and the risk-taking is happening in New York, arguably its Comey is not, during its operating life, in the BVI. It's just a brass plate situation with no employees. So, in theory, if we adopted UNCITRAL, there are some local insolvency professionals who may find themselves in difficulty in terms of having control of a foreign main proceeding. I know that vigorous lobbying is going on right now to stop in its tracks an attempt by the government to cause to be proclaimed the model law in the BVI. So it's an interesting microcosm. I see both sides of the debate. There are strengths on both sides, and I have no idea how it's going to wind up. Ross, what is the position in Cayman with your new insolvency law? Well, new I say 2008, I think.
Yeah, in the recent amendments to Cayman insolvency legislation, there was the introduction of a number of sections dealing with international cooperation, which I think were loosely based on UNCITRAL model law, but were apparently specifically designed and enacted for Cayman. They don't provide automatic recognition. It's entirely discretionary on the part of the court as to what recognition is afforded. But they do afford a suite of powers that enables the Cayman court to clothe a foreign appointee with pretty much the power that a local a liquidator of a local Cayman company would have. They do contain, though, the defect, I think is the only word to describe it, that came very much to the fore in the Singularis appeal, where it was the case that the Bermudan liquidators were unable to get discovery against the Bermudan branch of the PwC, because although a power to assist at common law existed, the Privy Council held that, that power would only be able to be applied to the extent that it would match or not exceed powers that a Cayman liquidator would have had under Cayman law. And again, there's an element of trying to prevent forum shopping for discovery there. But
so just so we're clear, Ross, you're saying some Cayman liquidators go to Bermuda and they asked to get documents against PwC, and they were restricted because they were restricted under powers in Cayman?
Because of the definition of the parties against whom they can seek these orders. They have to be what are called relevant persons, and they are defined under the Cayman insolvency law, and quite narrowly defined. There is an issue as to whether auditors would come with under the definition of relevant persons if they are officers of the company. If they were officers of the company, then they would be. But often auditors are not, and that question depends on the articles of the company and potentially the terms of the engagement letter under which the auditors are engaged. But it's a very strange restriction that was brought into the Cayman legislation by amendment to a 2009 Act. It came into force in 2011, where Cayman generally had the very broad liquidators' discovery powers that just about every other English-based common law system has, where you could ask for discovery of documents and examine people who have had knowledge relevant to the affairs of the company. And that was changed for reasons which maybe Chris Johnson can answer, but certainly I can't, and very much restricted so that it has to be a relevant person. In a hedge fund context, that would be administrators. It is obviously directors and officers, administrators, but it doesn't include accountants and lawyers on its face. So it's a rather odd provision that has come very much into the spotlight as a result of the Singularis decision in the Privy Council. I mean, there may be ways around it, that one of which was hinted at in one of the judgments in the Privy Council, where two of the Privy Council judges claimed not to be persuaded that the auditor's working papers were not actually documents that belonged to the company, which would be discoverable and would be under the local law able to be obtained. And so the Bermuda court, applying its common law powers to recognize and assist, would have been able to obtain documents if they had belonged to the company. But I think that point was conceded, that the PwC's documents did not.
These areas are important because it's not lost on first world nation bankruptcy court judges what goes on offshore. I had occasion to speak to a senior bankruptcy court judge in New York who was not happy about his conclusion about what was actually going on in the BVI. Not only have we not adopted insolvency yet, which sticks in his craw, but also our Part 19 of our Insolvency Act, called Orders in Aid of Foreign Proceedings, where there is a schedule to the statute now listing 9 countries, not very many. As it happens, they're predominantly well-known countries. Canada, US, Australia, I think, is amongst the 9. But if you're acting for a Brazilian judicial administrator of an estate, they're called there, or liquidators, you're not in the list of 9. And yet BVI has 600,000 or so offshore companies, 1/4 of the world's population of these vehicles. And our insolvency practitioners seek recognition in New York and elsewhere. And I'm telling you, U.S. bankruptcy court judges are not happy when they hear these applications coming from the BVI, and we have a mess on our hands with respect to recognition inbound. So I would dare say that those who are lobbying the government to stop UNCITRAL might be well advised to recommend at least that we expand the list of countries from 9 to 140 or something. Because Justice Bannister, who was a brilliant commercial court judge we just lost to retirement, our first commercial court judge, constructed the meaning of this part of the Insolvency Act to mean that it displaces the old 19th century common law rules of recognition that were quite flexible and that allowed the court jurisdiction to recognize the powers of foreign office holders to the extent that they were from the place of domicile or incorporation of a company or place of business. So Justice Bannister found, well, I have no power to recognize a non-scheduled country. Brazilian judicial administrator Gustavo, one of our clients from Sao Paulo, you're not allowed to get recognized in the BVI yet. However, Justice Bannister points out in other decisions that, and practically speaking, I would argue it doesn't really matter all that much in most cases because there aren't operating cranes or ships or buildings or skyscrapers in the BVI owned by a Brazilian estate. What you want to come to the BVI for are the ownership records of companies probably incorporated on behalf of directors of Brazilian bankrupt estates who may have been forming BVI companies for the unworthy purpose of concealing Brazilian estate assets. So you might want to come to the BVI. You don't need recognition to start an action for disclosure, Norwich Pharmacorp Bankers Trust disclosure proceeding. Justice Bannister agreed with us in submissions that his decision to narrowly apply the list of 9 countries had no application to bringing actions, as long as you could prove that your powers displace those of the directors, that you speak on behalf of the bankrupt company. So it's a controversial area, but we still are able to carry out remedies and do discovery and get the information you need to get for foreign office holders in the BVI. I guess the next point, Ross, what about recognition in inbound, I guess, in Cayman?
Well, that was the point that I made, that there are provisions and there are international cooperation provisions, but they do have a suite of powers, but they are subject to the same limitations that we now find that Cayman domestic liquidators have to deal with and have to face.
Now, Greg, what about the crane example that you wanted to mention?
Well, in discussions for today's topics, the notion, and obviously we see it from the opposite side of the states, when you're talking about an actual physical item of personal property, either inbound or outbound, if there was in fact an item of personal property in BVI or in Cayman, these cases are a grave concern because they are not going to allow the kind of easy recognition that we have in the States in the reverse. In the reverse, of course, if you have a BVI liquidator and there's a crane in the United States, you file a Chapter 15, check off really the ministerial boxes. You may have a fight about whether the center of main interest is BVI or elsewhere, but if you get past that hurdle, then you get essentially the ability to grab all the assets in the States, sell them, take the proceeds back, and pay them to your creditors. Very straightforward process. The scope of the power that a BVI or a Cayman liquidator would have is, of course, whatever is granted to them in country. And from the U.S. perspective, the way Chapter 15 is set up, it is the U.S. court is ancillary to the foreign proceeding. So it's not a U.S.-based proceeding, it's a Cayman-based proceeding or a BVI-based proceeding. And the proof is in the pudding there, which is Chapter 15 says that even where the property is a cause of action, the cause of action, according to the Fifth Circuit in the Condor case, is a cause of action under BVI law or under Cayman law. It isn't the cause of action under U.S. law. If it's personal property, it's even easier. Once you get recognized, then you're the company. You come and pick up your items. If they're real property, you probably sell it locally, send the proceeds back. If it's personal property, you may even take it with you. If it's, say, a stock certificate that has intrinsic value or something along those lines. It's a much more straightforward process. The limitations on power of a foreign liquidator operating in the U.S. don't seem to have the kinds of constraints that Singularis and Saad are talking about. So in some ways, shockingly, the U.S. is a little bit more cooperative than is typical in international worlds.
Next,
And Chapter 15 powers, as I understand it, are available to a Cayman liquidator regardless of powers that they may have domestically.
it depends on.
That's correct. Once you get past the hurdle, it's going to be, if it's recognized as a foreign main proceeding, the who is recognized. Whatever power that means under local law and BVI, if that means it displaces all of the management's power, then that will be recognized as displacing all the management's power. As far as what, if it's a cause of action being brought in the States, if it is the kind of cause of action that existed, whether or not there was a bankruptcy, then the trustee is the successor to the debtor and files the lawsuit. The lawsuit may or may not apply U.S. law, depending upon what kind of lawsuit it is. So if there's a debt to be collected in the States, you get recognition, you file the debt collection action in the United States, you collect under whatever law would apply to the debt collection action.
But in relation to discovery and examination powers, as I understand it, they are set out in Chapter 15 and have they don't refer back to the local powers that the Cayman liquidator would have.
That's correct. In Chapter 15, once you have been granted recognition, one of the line items, one of the things you get automatically, you get the automatic stay applying to all the property in the United States. One of the other things you get is the ability to examine witnesses, take discovery in anything having to do with the assets, the liabilities, or the affairs of the debtor. So if in fact your in-country discovery rules are narrow, say it's Brazil, or say it's some other place where discovery is not sort of an open transparency, then you get all of the US-based discovery powers. There is a little bit of a debate. Some of the New York judges have laid side by side the Chapter 15 discovery statement and our open discovery rule called Rule 2004, laid them side by side and suggested that they are actually different. In practice, having filed a bunch of these, at least in the Miami judges, the template is the same. It's a very broad, sometimes described as a fishing expedition, a court-sanctioned fishing expedition.
Greg, for speed and sometimes for efficiency, cost efficiency, what if I came to you from the BVI on behalf of a liquidator and said, Greg, can we not do a Chapter 15 because it's complex and sometimes quite expensive to get full recognition? I just want to get some records out of a bank in New York. Can we apply under the general Title 28, United States Code Section 1782, open square brackets, discovery and aid of foreign proceedings, close square brackets, where I can just put a little petition together for you to check and edit and file with a little affidavit, and we get subpoena power to throw around different bankers in New York or Miami?
I wish I could answer that as a yes or no, but if you are a private litigant and not a trustee, so just plaintiff versus defendant, you represent plaintiff in BVI or Cayman, and you have some third-party witness for the documents you want, you could open up what we call a 1782, file it in district court where the witness is or where the documents are, and you get a district court judge who gives you a discovery order. They happen pretty quickly. One of my law partners got one, I think 48 hours, we got one from a judge in New York. Our Miami judges, I think the longest one was 6 weeks or something like that. When you're talking about an insolvency trustee, it gets a little bit more complicated. There is a section in Chapter 15 that suggests that the only doorway for a foreign liquidator to get discovery in the U.S. or to do anything in the U.S. is to go through Chapter 15 first. Sort of like Chapter 15 is the gateway. You got to first get through the bankruptcy court. Once you're recognized, then you get whatever you want to do. There's some debate about that. There's an exception even within that notion. Hey, it's the U.S. We got exceptions to exceptions to exceptions, and we're exceptional. The exception to the exception is that if in fact all you're trying to do is a debt collection, then you can file that without need for recognition. So then the debate is, what's a debt collection? Suing for fraudulent transfer is not a debt collection. Collecting an account receivable is clearly a debt collection. Things in between, we don't have a lot of case law to describe it. The safest, most conservative approach is open up the 15. If you're doing it in Miami, you file your petition, you get about 35 days later, you have a hearing, final recognition, get your recognition order, then you've got a case number under the U.S. Bankruptcy Code, and you can serve subpoenas across the entire United States, anywhere. As long as you go to the place where the records are to pick them up, you can get nationwide discovery. So that was a long way of saying yes.
Yeah, that singularis doesn't cause a problem in the U.S.
No, the fact that your parochial rules are more limited, 1782 is a perfect example. This is a federal statute that basically says to the world, our citizens will have to provide discovery to you. And the idea was to encourage other nations to have a more open and robust discovery process.
I would think raw singularis is pretty narrow in this geographically, in the sense I think it only deals with common law rules of recognition and their limitations. So if you're in a statutory-based system of recognition like Chapter 15, which is UNCITRAL in the United States or in Canada, or I guess even the UK, which has also adopted UNCITRAL, I don't think the singularis limitation that your powers are limited to what they are in your home court would apply in many, many places like the European Union.
Yeah.
It's just simply offshore to offshore, I think, in the English-speaking jurisdictions.
Yeah, I think Section 423 in England would make that a no problem as well, where you can apply. It's in Section 43 in England has a similar effect, where the foreign appointed liquidator can apply for recognition under Section 43, and that carries with it the ability of the English court to apply either the local law in relation to examination and document production, fraudulent transfer, transaction avoidance, or English law. So I think you're right, there will only be certain jurisdictions where this will still be an issue.
When we don't have code-based, statute-based recognition rules, probably.
I do want to mention one thing. In the Fairfield Century case in the Second Circuit that came out in 2014, because it has to do, this issue comes up about the power. In that particular case, for those unfamiliar with it, there was a claim against the SIPA trustee in New York. And the claim was being sold to a third party. And they found a buyer. They supposedly got the highest bid they could get. This was BVI in the U.S.
It was a $7 billion Madoff feeder fund from the BVI called Fairfield Century, and the liquidator, Ken Chris, had done a deal with a hedge fund to dump, or on a discounted basis, this claim right for, I could be wrong on the figure, but it was, say, 25 cents on a dollar, and then overnight the settlement with the Mrs. Pickauer, the widow of Mr. Pickauer, found dead in a swimming pool in Beverly Hills, resulted in a $6 billion collection of value into the Madoff estate. And that settlement was secret, and it was published during the time that Ken Chris had obligated the estate to sell at a discounted basis the claim, and when the settlement was announced. So there was a value, the value of the claim shot up to 60, 70 cents on a dollar from 25, and millions were involved. So Ken wanted to get out of the deal.
The issue was, and I'm going to bring it back to what we've been talking about. The issue was the putative purchaser went to the BVI court to enforce the deal they thought they had cut. And the BVI court said, yes, you have a deal, but said, I'm not going to bind the New York judge because it's unclear to me whether or not this needed to have both courts' full approval. Then the issue went back to New York, in which Ken Chris went to the bankruptcy judge there and asked the judge there to disapprove the settlement, because now, after all, it's a terrible settlement given the current realities. Judge Liflin said, a deal's a deal, this is buyer's remorse, no, refuse, you're bound by it. District Court affirms, Judge Liflin says you're bound by the deal. Second Circuit reverses. And the reversal is what I want to talk about, because what's interesting about it, the reversal really stands for the very, not particularly exciting issue that says that where property in the United States is going to be sold, it must comply with U.S. Bankruptcy Code sale process. Since the property's in the States, it's being sold, it needs to comply with the U.S. Bankruptcy Code. The fact that a BVI judge may or may not approve it doesn't change Chapter 15's statutory statement. They determined that the claim against the SIPA trustee was property within the territory of the United States.
Because the obligor was in the States?
It actually says that the reason that it was property in the United States is that it was the type of intangible personal property that could be attached or garnished. Because that's actually in the definition of Chapter 15 of what tangible personal property, property in the United States.
And to attach a bank account or a shows or intangible claim, you got to go to the place where you can find the debtor, the person who owes the money.
And they held that under New York law, a chosen action is attachable, and it's attachable at the place in which the defendant would have to pay or where the cause of action accrued. So what I find interesting about it is the following, and tying it into the powers. If you're a BVI or a Cayman liquidator and you're trying to sell an asset in the United States, you must comply with the U.S. Bankruptcy Code. But in your Chapter 15 case, there's no estate. There's no proof of claims register. There's nobody who's made appearances there except for whoever it is that's been trying to fight against recognition, perhaps. So under U.S. Bankruptcy Code principles, when you sell an asset in the U.S., you need to give notice, an opportunity to object, and you need to have a court order.
Who do you give notice to?
Exactly. There's no service list. There's nobody to give the opportunity to object. So in a recent case, we solved this. It was not a sale, but it was a settlement, which has basically the same notions: to approve a settlement in the States, give notice, opportunity to object. We went to our judge in the States, and we got conditional approval. The condition was that our judge asked the judge in country, in this case it was Brazil, asked the judge in country to send notice to all of the creditors of the in-country estate that the settlement has been reached and has been conditionally approved. And if any of them want to object, they need to file their objection in the U.S. Bankruptcy Court, Southern District of Florida, by such and such a date. Speak now or forever hold your peace. And it worked out really nicely. The only strange thing was under Brazilian, they had never served anything like paper in their entire lives. So sending out 14,000 pieces of paper to their creditor body is probably the first piece of paper these creditors have ever seen in the bankruptcy case. But we did that for belts and suspenders. So I don't know what the result is of Fairfield, whether they finally got a new buyer and how they've gotten that sale approved, or if they've gotten that sale approved. But I don't know who they've given notice to, I don't know how they've given notice, and I don't know what process they went through to do the sale.
I don't think Ken would want to sell, or you mean resell it?
Resell it, yeah.
Why would he resell it? The value went up. He wants the money out of the estate.
But he'd have to wait. Maybe he gets to cash it out. I don't know.
No, the value went up to 70 cents. Ken wanted out. He signed a deal at 25 cents and $1. And there was a value rise because more cash went into the Madoff estate. So the last thing he wanted to do was to sell that claim once it went up in value, I think.
You could sell it now for
70 cents and $1.
73 cents and take the cash now. Maybe it depends on whether the dollar's strong or not.
Now we're going to move to the subject of setbacks for unredeemed shareholders in Cayman, BVI, and U.S. in the area of so-called clawback claims, where a hedge fund goes into insolvency. It may have been caught up in a layered fraud like Madoff. So in Madoff, we had many feeder funds offshore, like Fairfield Century. $7 billion of value were on its books on December the 5th, 2008, the day before Bernie Madoff's sons turned him into the FBI for the fraud. And then once the fraud was announced a couple of days later, the net asset value, NAV, of Fairfield Century collapsed from being worth $7 billion in the books of the shareholders, the equity holders of Fairfield Century, the BVI company, which included UBS and many major banks, on behalf of aggregated pools of other investors in Europe and elsewhere. All of a sudden they were being told, well, guess what? What you thought was worth $7 billion yesterday is in fact, in reality, and has always been, worth almost nothing. I think in that case $100 million caught up in a bank account in Dublin, Ireland, which we'll come back to about litigation over its clawing back into the estate, which is quite interesting, dealing with anti-suit injunctions. But Ross, why don't you take that background and then talk about the RMF case in Cayman and how Cayman courts are dealing with the issues related to what happens when you're looking at the balance sheet of these funds. There's a collapse in value. A bunch of investors want money back. Some have put in notices for redemption before insolvency, and their position in all this is uncertain and complicated, or it was until recently.
Yes, it was. It was something that we were waiting with sort of quite a degree of interest to have the first case deal with the application of what's called Section 37(6) of the Cayman Companies Law. This case came on the heels of the Privy Council's decision in Fairfield Century, so that theory that was adopted and tried to be asserted by the liquidators in Fairfield Century that they'd made a mistake, the payment was made on a mistake of fact as to the true value of the NAV.
So you're talking about a payment, you're talking about the situation of an investor in Fairfield Century, pre-discovery of Madoff fraud, and he's just an innocent investor, and he asks for his money back, and no one knows there's a fraud, and he pays his money back a couple of months before insolvency. And now the liquidator wants to take that money back, right?
That's right. And just you're aware, Martin, the Privy Council said no, that the mistake did not vitiate the contract. They'd given value by handing back the shares. And so that avenue of recovery for liquidators was effectively firmly closed.
But just to clarify, let's drill down. Whose mistake are we talking about? The mistake of the directors or the company that paid out all this value to an innocent investor before insolvency? You're saying is the liquidator said, well, I get that money back because the directors paid the money out under a mistake. They didn't understand there was a fraud going on. There was no value to pay the money out on.
Yeah. But that, notwithstanding that, the Privy Council and the BVI Court of Appeal held that that was an insufficient basis to seek recovery from the payee and closed the door effectively to that type of recovery claim. So in Cayman, there was another option that was available to liquidators, which relates to our Insolvency Act, where it centres on the preservation of capital rule, where it's held, and this is not an unusual provision, that it's improper, unlawful for a company to make payments
like a dividend,
out of capital when it's unable to pay its debts as they fell due. And in the case of RMF, Market Neutral Market Strategies, the DD Growth Premium Fund, liquidators attempted to run this argument as a grounds for recovery. There was no doubt that this company had effectively become a Ponzi scheme. The directors had significantly overvalued certain assets in the books of the company, and this had arisen on the back of the Lehman collapse. But it had tried to disguise the loss in the NAV, hadn't properly reported NAV values, and tried to tough it out to see if it could perform some sort of recovery and get back to some sort of solvency. And the plaintiff in the case, RMF, it became a plaintiff because it applied for negative declarations that monies that it had received were not liable to be clawed back. It actually did get some money out of this fund in the days of its death throw before the plug was eventually pulled. But the liquidator's counterclaim to say that the money that you go back has to be returned because it was paid out of capital at a time when you were unable to pay a whole load of other redeemers who had asked for their money back and who didn't get it. And the issue on this part of the case related to whether the money that the investor had paid for its shares actually did properly constitute capital of the company. And the court held that, well, the vast majority of it didn't. The shares had a par value of $1,000th of a dollar. 0.001 was the value of a share. So everything that the investor paid, except for that amount, was what they called share premium. And that it was always envisaged in a hedge fund context where you had an ability to invest and get out, that return of share premium would not be contrary to the preservation of capital, the maintenance of capital rule that had been developed, a judge-made rule that had been developed by judges over hundreds of years. And that was the long and the short of that aspect. The liquidators were unsuccessful in maintaining the argument that, well, they're returning shares to shareholders, that's in breach of the maintenance of capital rule and should be unlawful and should be declared unlawful, and we should have the right to recover what has been paid out of the share premium account that the company had established. And in that share premium account was everything except the 0.01 cent of a dollar that was the par value of the shares. So that other interesting and quite imaginative approach by the liquidators to recover clawback claims from investors failed. And it failed even on the basis, as the Chief Justice recognised, that this was very unfair to those unredeemed shareholders who'd remained in the fund, and it was also unfair to other redeemed shareholders who had redeemed because the redemption date had passed, but they hadn't been paid, but the company had paid RMF a certain sum of money. But he said that was just an incident of what happens when an investment fund becomes a Ponzi scheme, and that's the way the cookie crumbles, and you're stuck with it.
Although unfairness can be looked at from two sides, right, Ross? So it may be unfair to the innocent victims of the Stanford fraud, indirect victims, who also invested in the fund, and by reasons of coincidence or of timing of investments, they lost all their money, or could lose all of it. And so perhaps what's really happening in Cayman or BVI in these cases is a predisposition for commercial certainty, so that when hedge funds are erected, everyone knows where they stand. So when they're making a redemption request and the NAV is sitting at a certain value, that's it. So the courts are saying, that's it. Just because there's an underlying fraud happening in a different country, several layers away, that's it. Whereas if you look at Canadian or US-based judges looking at, with the exception of securities fraud cases, and Greg can explain what that exception is about in a minute, which probably parallels the one I'm talking about. You have, in the typical Ponzi scheme case that I've been involved in, one was called SEC versus IPIC. It was, I acted for Dennis Racine, who is Joey Levinsky's partner in Dallas, an SEC receiver at the time. IPIC was a Ponzi platform built in East Texas by a preacher similar to Burt Lancaster's role in Elmer Gantry, very charismatic character who picked on Christian affinity groups, Christian congregations across America in a major Ponzi scheme with the line, "The Lord loves you, the Lord loves me. The Lord has revealed to me that if you provide your money to me, he will rain money down upon all of us," through the investment strategy I've developed, which was a one-way single entry accounting exercise where he stole all the money. And in that case, and many others like it, US and Canadian judges are saying, look, the Ponzi scheme was insolvent from the inception of the scheme. The current liabilities exceeded any expectation of the value of assets of the company from the day it began trading in this improper way as a Ponzi scheme, which has a number of serious legal consequences. One of which is that when people file proofs of debt in the insolvency, they have to get rid of all this pretend or fictitious rates of return or interest they were promised. We're going to restate the Ponzi accounts for proof of debt purposes to cash in and cash goes out. And you have a net cash position. If you're net cash deficit position, you have a valid proof, fair play to you. If you, on the other hand, are a net surplus, clawback. You're a net winner, we're going to start clawing back money from you because you profited from the scheme, and that's unfair to those who've lost. And And then furthermore, we can start looking at people that have taken money out, or that are net losers, but took money out, say, in the last 6 months of the operations as a type of preference clawback claim. But the point is that there's no result saying, oh, the day that you got back your money is the day we fixed the value of the asset. So they have very different results in Cayman BVI, in the Madoff case on these hedge fund platforms, versus what you see in your common variety Ponzi scheme approach by judges onshore. And I guess, Greg, you have a thesis to explain why this is.
You know, when Fairfield Century first came out, and obviously RMF was an attempt to try and get around what was perceived by the folks in RMF to be a bad decision. But when you go back to Fairfield Century, the notion that the delivery of this piece of paper called certificate, however they defined it, I think there was a debate about what does the piece of paper need to be a certificate. From a U.S. practitioner's perspective, this is crazy talk, because we have many cases from the beginning of the bankruptcy world that says we look at substance, not at form. So the fact that there's a piece of paper that says certificate doesn't change a hill of beans difference. What matters is whether or not the person received the money within the period of time, the look-back period, whether or not what they got versus what they gave is, you compare one to the other, and if they got more than what they gave, in this particular circumstance, they got full payment and everybody else got screwed. So from a U.S. perspective, this seems odd. But if you put a template on top of it, sort of putting a legal realism hat on it, Cayman, BVI, these are jurisdictions that live for the hedge fund world. If in fact there was not this kind of commercial certainty, it would have a ripple effect into the economy of these countries. And so that you don't think that I'm being parochial about it, we have our own in the States. We think that anything that creates a ripple in the stock market will do such incredible damage that we've basically said, if in fact the transfer involves the settlement of any securities type contract, irrespective of how badly everybody else gets harmed by the result, we are going to allow the securities contract to complete, the settlement to be made, and no one is ever going to touch it. So if you think about it, again, purely legal realism, what's important in BVI to keep the hedge fund world in a matter of certainty is very similar to our safe harbor provision that I'm referring to, the 546. I think it's, got the section number of it. The safe harbor provision that basically says anything that has to do with a securities transaction involves any kind of commodities changes, settlements of margin payments, etc.
How about a pump and dump fraud, where the mafia takes over a company and lies about its performance and pumps the value up of the securities and dumps it, like Bre-X Minerals out of Canada?
If in fact the pump and dump used Merrill Lynch or an investment banker in between or the regular securities markets as intermediaries, yeah, because we care more about the commercial certainty of not creating ripples and impacts on our stock market, that we're okay with little old ladies getting no recovery, and people keeping it.
But you have to be an innocent participant in the market, right? You can't be an insider through an offshore company.
Yes, I mean, our safe harbor is not unlimited safe harbor. It says that any of this comparing apples to oranges, if you gave more than you received, then that's going to be a fraudulent transfer. That's what's covered by the safe harbor. If there's actual intent to delay, hinder, and defraud, and the person who received it does not qualify for good faith, then that's still going to be recoverable. But good luck proving that Merrill Lynch, as the securities intermediary, acted with knowledge that there was in fact a fraud going on. And this is one of the hundreds of thousands of transactions that went through them as intermediary every day.
So we're going to switch slightly to an example of an offshore center that has an underdeveloped insolvency law, Antigua. This is not unusual in the Eastern Caribbean. Many of our Eastern Caribbean nations or jurisdictions have underdeveloped insolvency laws. So in the case of Stanford International Bank Limited in liquidation, domiciled in Antigua, I act with Ed Davis's co-GCs, General Counsel to liquidators from Grant Thornton. Nicolette Doherty was here a minute ago as our local counsel in Antigua. Link Kaler is in Toronto. We have a large team. But in Antigua, our clients wanted to examine carefully, critically, what happened in the last 6 months of the operations of the enterprise. It was a bank, ostensibly a paper bank. It sold certificates of deposit to depositors. When the merry-go-round stopped, in rough terms, $10 billion of cash gone in the bank for over a period of 17 years, and about $5.5 billion went out of the bank back to depositors in repayments of their principal sums or ostensible interest, which was built not on any genuine economic activity to speak of, just classical Ponzi payments from new depositors paying off old. So $5.5 billion is the whole, is the deficit on a net cash basis. So you net the cash out, you get $5.5 billion owed to 22,000 people from 140 countries. Our clients pointed out when they analyzed the books that about $1.5 billion or so of cash had left Stanford Bank in the last 6 months of operations. And we all believe that it relates directly to what was happening in the larger market. You recall in 2008, in the spring of 08, Bear Stearns collapsed. Spring of 08, you had Lehman Brothers collapse. And that was about 6 months before Stanford Bank collapses on February 19, 2009. You recall Madoff was discovered, as I said, December 6, 7, 2008. So you had all this bad news happening, and you had of $2 billion of cash sitting in Stanford Bank, you had 1.5 of it walk out the door to various depositors. So what we have done is brought a clawback action provisionally, subject to a review that's going on right now in the court in Antigua as to the appropriateness of the clawback regime and solution that we've come up with, because the statute in Antigua has no clawback provisions that you would find in a more modern form of insolvency statute. You can't look up and see preference or undervalued transactions or fraudulent transfers. There's no such lovely, well-articulated set of rules. So we met with these facts. We had to provide a solution. Also, we have net winners. We have about the number is about 14,000 people who fall into the clawback basket. 2/3 of them are people who are net losers, but who got money out during the last 6 months of the operation during the run on the bank. So that you would normally look at them for preference clawback claims to see if the preference they enjoyed during that 6 months can be or should be clawed back or not. And then 1/3 of the 14,000 people are net winners. They got more money out of Stanford than they put in. So the net winner claim, I think, is a straightforward one. I think the court will approve that. The more complicated one are the preferences. What was the solution? Section 204, we read, and we kept reading it in the act. And I wondered, where did this come from? It's an oppression remedy section. And I had remembered reading it somewhere else. I just couldn't remember where for a long time. It said basically that the court has the power upon an application of, and then the list of number of people, including liquidators, in cases involving any act or omission dealing with the company's property. So anything, any contract, any payment, anything, the court has the power if there is any form of oppression or unfair prejudice or unfairness in terms of the interests of any, and then lists a group of people, including any creditor. The court has the power to rectify or remedy any transaction involving the company's money or property if it was unfairly prejudicial or unfair to any creditor. So that seemed to me, in terms of the plain, ordinary meaning of the words, to mean that we could mount our clawback claims on the basis of this oppression remedy provision that I couldn't figure out initially where it came from. And then I remembered in 1981 from company law at the University of Saskatchewan Law School, I remembered that provision was in the Saskatchewan Business Corporations Act. So I looked it up, and then I found it in the Canadian Business Corporations Act, and it all came from the Ontario Business Corporations Act, and all across English-speaking Canada, it's the same provision in there. And then we started looking at the case law, and we discovered, well, the Canadian courts had not needed to use this provision as a clawback rule because we have federal and provincial sophisticated clawback rules. It's used more in minorities being oppressed by the majority, the classical reason to use an oppression remedy provision. So, however, we convinced our court in Antigua to appoint a third-party independent amicus curiae, friend of the court from Britain, a counsel from the London Bar, to make representations on behalf of the creditor community against our clawback, structure or claim, and the court's got reserved judgment. So soon a judgment will come out from the court as to whether it's appropriate and lawful, and on the face of it, reasonable for liquidators to pursue this course under this provision, which does not at first blush look like it's a clawback provision, but actually when you read the words it seems to be so. This is an example of when you go down island, you've got to look through the statutes and find a way to construct a platform for clawback, because it's not so easy on the face of it. Now we're going to move over to Greg to talk about two decisions on this whole subject of setbacks for clawbacks.
There's been some developments in clawback actions, the cross-border clawbacks out of New York. There's now seems to be two cases. I'm going to give you one that just came out in January. Two cases talking about the extraterritorial effect of U.S.-based clawback actions. The first one is in, again, one of the Madoff fraud cases, where the district court affirmed that the bankruptcy code section 550, which is the implementation section for both fraudulent transfers and preferences, does not have extraterritorial effect. And that's really not a big surprise. We've had some cases that have been talking about that being more of a conflict of law rule analysis than in fact an extraterritorial application. The notion is fairly straightforward. Your debtor may be a U.S.-based debtor, but if the transfer is made between a non-U.S. person and another non-U.S. person outside the United States, you're not going to apply the U.S. bankruptcy code. So, for instance, if you think about fraudulent transfer law, you can have the initial transferee, and then you can have a subsequent transferee. Well, if the initial transferee is non-U.S. and the subsequent transferee is non-U.S. and the actual event occurs outside the states, then it makes sense that you're not going to have an extraterritorial impact to be able to sue under the U.S. Bankruptcy Code section. The more interesting case just came out, Judge Glenn in the Southern District of New York, in a case called Hellas. There's not even a bankruptcy reporter site yet. There's just a Westlaw site. It's 2015 Westlaw 373647. This is a long case, but it is literally every issue that you have gone to any of these conferences on clawbacks, it's in there. So for instance, the first thing that Judge Glenn tackles is the condor issue. Fifth Circuit we talked about before says foreign liquidator can't sue under U.S. Bankruptcy Code clawback actions. They bring in that case it was Nevis, and sue under the Nevis fraudulent transfer notions. In the implementation of that here was that the foreign representative tried to sue a variety of defendants, not using the U.S. code-based United States Bankruptcy Code 548, 547, but tried to use the New York State fraudulent transfer statute. Judge Glenn knocks a whole bunch of defendants out on personal jurisdiction grounds, basically saying they don't have enough contacts with the U.S., they're out. He then proceeds to knock a whole bunch of defendants out of the count suing these folks for what's called constructively fraudulent, they got more than they had given. And he knocks them out on the following basis. He does a conflict of law rule analysis and says these transfers are more relevant to either, in this case, either the UK or Luxembourg, not New York. He doesn't decide whether it's UK or Luxembourg, but he says it's certainly not New York. Once he decides that it's not New York, he then knows that under UK and under Luxembourg, they don't have this animal for purely constructively fraudulent transfers. So he knocks that count out. He then goes to the count that alleged actual intent to delay, hinder, and defraud. And he knocks the foreign representative out of the box again and says the foreign representative doesn't have standing to bring that claim under the New York statute, because the New York statute is a creditor claim, and the only people who can bring that claim are creditors. If I go to the UK law says that the foreign representative's powers as creditor is only to bring a particular cause of action, and that particular cause of action has a 2-year look back, and all these transactions occurred more than 2 years. So we all obviously know why they filed in New York under New York State. They wanted a 6-year look back. And he says, since the only statement in UK law about when this liquidator could apply a creditor-based remedy was for this particular one, and that doesn't apply, they have no standing to file under the New York fraudulent transfer statute. The only claim that still remained after he wiped out everything else was an unjust enrichment claim. And in that unjust enrichment claim, the defendants argued in pari delicto. So then he spent the next 16 pages or so talking about all the things we talked about at the beginning of today. See how I brought that all the way back to square one? He talks about all of the different issues we talked about in pari delicto and ultimately says, not enough facts here to dismiss on this basis. That claim stated enough of a cause of action to continue. Besides all that, he also did the safe harbor that we talked about before for securities transaction. It's a good read. It's literally, it's every issue that we've talked about in these conferences over the years is in there.
So, yes, we just have a couple of minutes. Just a quick point about the development in the BVI in 2014 in Shell and Ken and Chris, again, dealing with Fairfield Century. You recall I said that when the NAV collapsed in that fund from $7 billion to around $100 million, there was $100 million of cash still sitting in an account of Fairfield Century in the Bank of Dublin. Shell, a pension fund arm of the Shell Oil Company in the Netherlands, brought a local Netherlands-based attachment proceeding and got a writ of attachment in rem against this value sitting in Ireland, and then took that order and had it recognized, or sought to have it recognized in Ireland. This notwithstanding the BVI liquidation, the liquidators stays of proceedings, and for reasons that I don't understand, the Shell pension fund in question filed a proof of debt in the BVI liquidation. So when Ken Chris needed some money for the estate to run it, this $100 million meant a lot. And so he obtained an anti-suit injunction from Justice Bannister prohibiting the onward attack against the estate's monies in Dublin by this creditor who sought to be proven in the BVI's liquidation or winding up. And he concluded, well, that's an attornment. You've come to the BVI, you've submitted to the jurisdiction of the court, this is a winding up proceeding, you're not allowed to get it, elbow your way in ahead of all creditors towards company property, and I'm going to stop it. It goes up to the Privy Council, and actually, the Privy Council ruled, it imposed the anti-suit injunction. So it seems that Ken and the estate will recover this money there if they haven't already done so, prohibiting Shell from carrying on the litigation company. With that, are there any questions from today's remarks? No? Oh, it's one. Yes.
A question probably to Craig mostly. In your experience in pursuing insiders and overcoming the impari delicto defense, have you found that trustees in bankruptcy fare differently or not as compared to receivers seeking to overcome that defense?
The case law, the receivers have traditionally fared better. The Scholes case out of the Seventh Circuit, where Judge Posner says, essentially, the receiver, as the representative of the creditors, is not bound by imperi delicto. He uses very colorful language about once the receiver is appointed, the people acting are no longer zombies under the control of the bad actor. And there's actually a very specific reason why receivers were doing better, is that all of the bankruptcy case law that was imposing imperi delicto was applying the statutory provisions of the bankruptcy code. What is the estate under 541? What are the powers of the trustee under the bankruptcy code? But I believe the trend is moving away from imposing this imperi delicto obstacle to trustees. In Florida, for instance, we have our state court judges have been much more accommodating to trustees suing insiders. Frankly, it doesn't come up so much with the insiders. It really comes up with the third parties, the auditors, the accountants, etc. And the Florida state court system has done, the movement is afoot. We haven't seen that much. Actually, our assignment for the benefit of creditors statute has a specific provision that says imperi delicto does not apply as a defense to an assignee under an assignment for the benefit of creditors. Or it's assignee. So one wonders whether or not you put a company through an assignment for the benefit of creditors, get an assignee, the assignee then sells the cause of action, and then the person who pursues the cause of action is not bound by imperi delicto. I think the trend is moving away. God only knows if we'll ever get Congress to take up the bankruptcy code again. You know, we just had the review commission. If they ever take it up again, maybe there's an opportunity to fix this once and for all, because it's a stupid obstacle. All it does, the idea of imperi delicto was to try and not promote fraud, and instead, the imposition of imperi delicto is doing exactly that, is promoting fraud by allowing people to escape liability for helping fraudsters out. So this is just, the whole thing is asinine, but that's just my opinion.
Chris?
Two comments. First of all, in New York, Judge Lipland, who passed away recently, and Judge Grossman, who retired, were two very most proactive judges in giving very supportive opinions in recognizing and providing benefit in regard to cross-border insolvencies. With their passing, you may see a substantial change in the way New York bankruptcy judges look at all these different issues. If you look back at history, the Third Circuit strongly supported Judge Lipland in every decision he made. The Fairfield Century decision actually came down after Judge Lipland's death. And so that may have been one of the reasons that decision ultimately came down. So one issue is that while the case law has been very well established in New York in the past, these issues, that may be changing, especially with decisions like Judge Morris. The second issue is that one of the criticisms by the offshore jurisdictions, BVI and Cayman, is the issue of dealing with combing and saying that unless there's a main or non-main proceeding or establishment, then you can be recognized. UNCITRAL is now addressing a model law for the recognition, for group enterprises as opposed to single companies. And if you look at the website, there's some materials, but the approach so far has been combing, establishment, main or non-main, are not controlling, they're not. The issue is that if you have a number of different entities, say you have 40 companies operating in different jurisdictions, they all have their own combing, and you can't have a combing concept because of that. And so the issue is that there's at least a recognition of the work group so far that in those situations you should select the best jurisdiction that allows the most favorable treatment, whether you're trying to do liquidation or reorganization.
For corporate group.
For corporate groups, exactly. And that would hold true in liquidation, that would hold true
not in single companies, but in multiples. So that may resolve, or may at least help resolve some of this.
But you think that the offshore IPs are going to get on board with Unsa trial because there might be a group Kenney concept coming down? I don't think so. I think a single entity, BVI entity, the IP's got parochial concerns about wanting to run the show and not have it all get sent to wherever it is that the investment decisions are being made. It's not pejorative, it's just fact, you know. It's just fact. And I think it's part of their economy. It would be asking Delaware to give up the venue provision of the bankruptcy code to allow Delaware corporations to file in Delaware that have no connection to Delaware other than being a Delaware corporation. Whenever I talk about these things, it's not casting aspersions, because whenever when you're pointing a finger at somebody, there's four fingers pointing back at you. We do it in the States all the time. We have all our own kinds of protectionism. You just have to
How
recognize
about
it.
no anti-money laundering law in Delaware and Delaware? Kenney, for sure. I think we should call it to a close. Thank you so much for your attention today.